Before we dive into today's topic, just a quick note. If you're not on my email list, you're missing out on two things I send every single month. First, my monthly newsletter with deep dives on case prep, trial strategy, and witness preparation. And second, my focus group trends report, where I share what's actually happening in jury research right now. That's two valuable emails each month, and it's free. Just head over to larricklawfirm.com/newsletter. LARRICK lawfirm.com/newsletter after this. Okay, now let's get to this episode where we talk with Michelle Gessner about her recent verdict using AI. Hello, and welcome back to Trial Lawyer Prep. I'm your host, Elizabeth Larrick, and we have a returning guest for you today to talk about a recent verdict, and more specifically about how to use AI to create visuals for the courtroom. So welcome back to the podcast, Michelle Gessner.
Thank you so much for having me again.
Of course. If you didn't know, Michelle joined the podcast back in December of 2024, where we discussed her $21 million verdict against Wells Fargo. I'll have a link in the show notes for those episodes, but if you want to know, that's episode 128 and 129. But for this episode, I want Michelle to talk to us about a recent verdict success, but more specifically about her use of technology to go into a no technology courtroom. So, Michelle, give us just a quick billboard about the case. And again, don't worry, everybody. Michelle is 100% a fabulous employment lawyer, but what she is going to teach us today cannot be applicable to any type of law that you may practice. So, okay, Michelle, let me get out of the way. Tell us a little bit about the case.
Sure. This particular case was a sexual harassment, hostile work environment case that was filed in Wilmington, North Carolina federal court. All of the parties lived in Sneads Ferry, North Carolina. The employee was a front of the house manager in a local small restaurant who had, unfortunately, she testified the biggest mistake of her life, had a relationship with the owner of the business. They had worked together, they started a relationship, and then as adults, they thought the relationship could end and still work together. That didn't happen. And so the claims in this case were sexual harassment, hostile environment, together with some wage and hour cases. Once she filed her hostile environment sexual harassment case, the company then withheld her bonuses and withheld some of her wages. So that's just the elevator speech, if you will, regarding the case. It was filed in Wilmington, North Carolina in federal court in the Eastern District of North Carolina. And for those of you who may or may not be familiar, the Eastern District of North Carolina is a really large geographic scope. And so the parties lived in Sneads Ferry, which is on the coast, close to Topsail Beach, if anybody knows that location. And the case was filed in Wilmington, but we were assigned a judge in Raleigh. So immediately we had a different location for where this case was ultimately going to be tried, as opposed to the community in which these people lived. And then the case got moved. So after summary judgment, the case gets moved to Elizabeth City, North Carolina, to a different judge. So the furthest point away from Wilmington, North Carolina is Elizabeth City. So it's really close to Norfolk, Virginia, about 45 miles outside of Norfolk, Virginia, closer to the Outer Banks. So that's where the case was ultimately tried.
And what's so special about this particular judge?
Okay, great question. So just backpedaling a bit, our original judge was Judge Dever. He's in Raleigh, and he's pretty high tech, very high tech. Everything was expected to use the video equipment. Every exhibit was expected to be uploaded. Again, documents were backup only, which is the norm in most federal courthouses. However, in Elizabeth City, the courthouse is very old, and there's only really one major courtroom in that building. So that particular judge, Judge Boyle, who happens to be the longest standing federal court judge in the United States right now, who's not on senior status. So I think that's important. This courtroom had no technology, none. So there's one outlet, that outlet, there's a lot of extension cords. The clerk uses that outlet, and the court reporter uses that outlet. So there are no microphones, the judge or us. There are no TVs. There are no projectors. There is no overhead projector. The only thing you have in that courtroom to try your case is your voice, foam boards and easels if you bring them, and notepads. That's it.
Yeah. So you were gearing up for a different kind of trial. They switch it around on you. And so before we jump into, that big change up, because that's the main, what we're going to talk about, what I want you to walk us through is preparing for trial just generally. You knew that there were going to be some immediate hangups that people would have, okay, you had a relationship with the boss, but now you're suing the boss, so you knew there were going to be some issues. So talk us through a little bit about using focus groups to kind of figure out strengths and weaknesses. And then we'll talk about how you pivoted to visualizing that for the courtroom. So walk us through the focus group planning.
Sure. And of course, I have to give props to you, Elizabeth. Again, helping us through the focus groups from beginning to end in this case was huge. And we did a lot of focus groups, as we always do when we're preparing for trial. But this time, having learned lessons from the Billiston case, the Wells Fargo case, we started pretty early with focus groups. So we learned early on that we needed visuals because there was a large time period. This employee had worked at this restaurant since, I think, like 2017. And the time frame of the trial of this case was October of 2025. And so there was a long time period. There was pre-relationship, there was relationship, and then there was post-relationship. But focusing only on the claims, which were obviously post-relationship, there was still a large scope of time there, mainly because of COVID. So what we learned during focus groups were several things. And just really given the high level is that a timeline was really confusing. Having a timeline of events here, of just dates and events that happened, it was so much time that needed to be covered that the critical events that you really wanted the jury to focus on were getting buried. So that's one thing that we really learned, and we would not have learned at all but for focus groups. We also learned what jurors were not going to be great for us. What characteristics about someone's background or whatever biases they bring that you wouldn't be able to we can get to voir dire in a minute, but if you got any voir dire, you weren't going to be able to even ask about. And so that helped us in picking a jury, in knowing really what juror sentiments were going to be under this fact pattern. We knew we were dealing with a small restaurant. We knew we were dealing with this prior paramour, this prior relationship, and people were polarized about that. You get what you get if you have a relationship with the boss, and other people, no means no. And there was demographics, it was across demographics that people really believed one or the other, but it was really their personal experiences that made them have an opinion on those issues. And so multiple focus groups on not only visuals, what we needed. Early on, it was, what do we need to put on the screen? What do they need to see? What documents do they need to see? What are the critical pieces of evidence that in opening statement, I really want to hone in on, and how to do it? And then, of course, we tested opening statement as well, but we had to pivot because a lot of the focus groups were reliant upon being able to do it on the screen. So then not only were there issues with creating the timeline, it was then how do we bring home some of this critical evidence? So let me, if you like, I'll give an example, which is in this situation, it wasn't bad acts, if you will, of sexual harassment or a hostile work environment in one setting. I call it like a dog bite. It was like one little bite, and then the bite gets bigger, and the bite gets bigger and bigger and bigger. And looking at just one, it might not be enough for the jury. They may not see that this was really harassment that affected her in such a way to deliver the verdict that they did. But what we were able to do is take what we wanted to really try to portray to the jury and then put it into AI. We used ChatGPT and a couple of other sources to say, what's a good way to demonstrate this? And, I didn't really even know how to describe this other than to say, progressively bad behavior that got worse and worse. And so working with AI, it came up with, and Elizabeth, it came up with, circles and really starting thinking like a bullseye. And we started with what was initially happening. So initially it was name calling, talking about her behind her back, really bad mouthing her to other employees. And it was more words. Then the circle got bigger. The second layer of the circle was grabbing her arm, knocking over tables in the restaurant, pushing her, screaming at her, yelling at her. And that was a second circle. And then the third circle, which was bigger, had even more. And it was very egregious. It was kicking in the bathroom door in front of customers while she was using the restroom, going to her house, kicking in her front door, breaking into her house, having someone to program her garage door so they could open it, putting a tracker on her car. And so it was, even initially with AI, I kept thinking, how am I going to do this? How am I going to show this to the jury? But one of the things that came back that was really helpful was, I think an old school picture book where you flip through it, like the cartoon books. You had to draw it on every page and flip through it, and that really brought it to life. Well, that's what it suggested that we do, and we did, which is start with the small circle, but then when you show the second circle, keep the small circle on the board and just show it continuously getting bigger. And so then you see all of the hostile environment facts, all of the evidence that supported the case related to how she was treated on the job in one poster board, and in one slide. And so, but for having known exactly what the jury needed to hear, and did the sequence matter? Was it the sequence of events that happened, or was it the severity of the events that happened, or both? And did the dates matter? Was it more just, it didn't matter when this happened. If it happened at all, it was critical. And so, again, I would say that that was a critical demonstrative to bring to life the evidence very early in the case that we only learned through using focus groups.
Gotcha. And I would say, just to kind of go back with the focus groups that you were doing, and just kind of break this down a little bit. So what I hear you saying is, number one, you had a list of bad behavior, and initial attitudes fell into two camps. And I remember, we were at the time using kind of neutral narratives. If you're thinking through, like, how did she focus group this? She did, again, if you listen to the other episodes, small chunks at this, 1 hour at a time, 1 hour at a time, 1 hour at a time, again, just to figure out, okay, what are the attitudes, what's the blush, but also the ranking of the behavior, which, Michelle, you did a great job describing. We initially were putting this on a timeline. And if you did that, there were large breaks in time, and it was hard to see an escalation. Like, it was hard to kind of picture, do that as well. So that significantly helped, I think, because what we learned were, once the behavior got to a certain place, it was almost a tipping point for the jurors that were against us, where they're like, wait a second, this is well beyond whatever their initial blush was. So I will say, thinking through, like, she had a long list of stuff, but we didn't know, is this enough to get other people on our side? That kind of good stuff.
One of the other things that came out of what you just said is how much people are willing to put up with. A lot of jury sentiment on that particular issue was, why didn't she just leave? So we had, that was polarizing with, what is too much? And then why didn't she just leave? Some people thought she should just quit. She should have just left as opposed to stand up for her rights. But also, people are very, employees are willing to put up with a lot of really bad behavior and just walk away because they're fearful of the system. That was something that we learned out of those focus groups as well on those topics you were just discussing.
Absolutely. And I think one of the things, the context that was so important for people, again, knowing, you knew from the very outset, we're not going to be trying this case in the neighborhood. We're not going to be in the community. So we have to set context, and what context was important, if we were a rally or where we're going to be. And so, I think also one of the things you learned was, okay, we need to tell them very upfront, like, she's making really good money working at this restaurant, and she did a lot of things to increase profit. I mean, she had put a lot of blood and sweat into the restaurant to make it what it was. And so, she had kind of a vested interest well before the romance. And, so there were really good context clues that helped us. And again, thinking through how Michelle did it, she tested little different contexts along the way that, basically, Sneed's Farm's this tiny place. There's nowhere to work. she got this job, like was doing really well, like so well he promoted her to a manager. Then they start dating, and then, then the roller coaster begins. But I do think, using focus groups the way that you did here in this case was really helpful then, like you said, for the very beginning to figure out, okay, how do we take all this information and make it into a digestible visual that gets people, like, even if we have people who are against us, because that's my next question for you about, like, okay, so you did all this research, how did it pan out for jury selection? Knew that, we would have a tipping point for people where it's just like, whoa, this is well beyond that. So tell us a little bit about how, you worked hard to kind of figure out juror demographics. You were going to get ready for voir dire. How did that turn out ultimately a trial for voir dire?
Well, for voir dire, we didn't get any. The judge did it. In fact, I had not tried a case in front of this judge before. And so when we walked in, there wasn't really a large group of people in the jury pool. There were maybe 15, maybe, 15 to 20 max. And we received a seating chart with 13 people's names already, a seat assigned. 13 people were put into the box, not called. They were just put into the box. And the judge proceeded with voir dire. So we didn't get to ask a single question. So I had to listen very carefully. I had to have a jury profile really built. And to your point that you mentioned earlier, and this is really important, one issue, one focus group. So every focus group, we really tested one issue. And so we did get some extraneous issues associated or extraneous information that we were able to use, but really we were testing one issue at a time. But I had a jury profile based upon those focus groups. We had researched very significantly the demographics of the counties from which the jury was coming, and voir dire took less than an hour. And the judge, I'd asked him if we could ask questions. He said, nope, absolutely. And he brought us up to the stand and said, do you guys have anything else you want to ask? And we gave him a couple things, and he asked, but we were literally going off of the information learned from the multiple focus groups that we had done, the information that the jurors shared with us, to the questions the judge asked, and really some of the demographics of where people were pulled from. And I thought that was really important for the verdict. This particular area of North Carolina, the average income for most counties was $25,000 a year. The highest was Dare County, which is the Outer Banks, and it was slightly higher mainly because of tourism. And a lot of restaurants, retail, et cetera. Now, we didn't get a single juror from Dare County. It was about an hour drive to get from there to the courthouse in Elizabeth City. So just from happenstance, I don't know. Of course, we will never know, but we didn't get any jurors from Dare County.
Gotcha. So super helpful. Now, let's walk back through. I want you to kind of break down how you, and again, I don't need you to get into my nitty gritty here, but tell us a little bit more about using AI to get creative, if you can.
Sure. Yeah, I can do that. So again, feedback from the focus groups and knowing what were our strong points and what were some of the places we really needed to do more to show them what was happening. We needed AI's help. So I was able to put into AI really almost hypotheticals that we could come up with and to see if they could come up with more. And they did. It did. I say they. I call ChatGPT Chet. So Chet came up with more. And then just refining it. And it came up with ways to the circles that I was telling you about. The other way was, checklists. Think about the right way to do things, even for a small business, versus the wrong way to do things. And there was a checklist that I was able to use for every witness. I didn't have to check off anything, but it was really the right way to run a restaurant, the right way to treat employees. One of the things focus group told us is, what do people expect from small restaurants? Is there a distinction between what they expect from the large mega companies compared with a small mom and pop at the beach? Those were the kinds of things we got from focus groups. And then how to bring that to life, what words to choose, how to put them on something that I could use throughout the trial. So I had one checklist that I really use with every single witness. One other thing I would say is, defendants called in witnesses. I think there were 4 people that I had never met, never deposed, never heard of. They were listed, on a discovery response. So my cross-examination of each of these people was very short. but really focused on the things that we had already researched. And I used those checklists really to bring them back around. And so it became a little bit of a security blanket, if you will, during trial to attach to the checklists and the circles, the evidence on the circles that had come in, to really even cross-examine people off the cuff. I had no idea they were coming. They didn't disclose who was coming ahead of time. We didn't know the order of the witnesses. It was a true off-the-cuff cross-examination, but the jury focus groups together with AI on how to present some of the information we needed, it became a way to just circle back, really echoing back some of what other witnesses had said and really getting some of these unknown witnesses to just substantiate what other witnesses had said, but using as a tool. I'm showing you my hands because I had a foam board.
Yeah.
We'll get to that had these checklist items on the right way and the wrong way to do things. And it just became a visual that I could connect each witness with that I could just use over and over.
Right. And, just to, tap into a little bit of that, like what you're doing for the jury, which is one organization. And you're being repetitive in a way that is appreciative, not, there are times where people will echo or repeat something and it's too much. It's like you're hitting them on the head with this, like this is not persuasive, versus the way that you presented it was an organizational tool for both of you, for you, but also just to know, like, we're all on the same page, even though these are, and again, because the jury doesn't know at that point that these are people you've never seen before, you've never talked to before. Like, they don't know that, right? And so even if you ask that question, have we met before? That still would be lost on the jury. So I love that you and you did this very well in the Bilston case, which was like, I'm sticking to my guns. I know what this trial is about. I am not changing what my theme is, or just because you're throwing a new witness at me, or in the case of the Bilston, and I'm sure this case too, which was testimony you had never heard before about your particular client. So awesome. Let me take it back just a second here, because I know a lot of people, when we talk about using AI, we talk about using visuals, there's always a little pushback from lawyers, especially maybe even in our mind, like, it's going to get objected to. I'm going to have to show them like this foam board ahead of time. So tell me how you walked through that in your mind. And then again, if you faced any of that at trial.
Yeah, great question. I did focus the demonstratives, all of them, the circles as well as the checklists, on evidence that I knew was going to come in. Either it was in a deposition, it was in a pleading. It was not something that I think was ever going to be objectionable. It was more about organizing it in a way that it was effective. So AI helped me do that. I was able to upload, depositions that were already filed. The Eastern District makes you file your full deposition when you file briefs, the summary judgment briefs. So we normally don't put anything in AI that doesn't have a filed stamp on it, because at least then we know it's not going to get disclosed in any way. And so, making sure that whatever I have in a demonstrative, there's a record cite to it in case that I have somebody to question me on it. This judge did not require us to share the demonstratives before the first day of trial, but on the first day of trial, we did. We shared. I didn't want to get the objection during opening, and so opposing counsel had an opportunity to see everything that we were going to present, and I was ready for those objections if he was going to object, but he didn't. And so, but yes, so the perfect world is make sure you've got a record site and you really got like a pocket brief ready, that if they're going to object, you're creating your record to show that you're not showing something that they haven't seen or heard of before. It might just be the way it's being outlined for the jury. And then the second is, if you want to push the envelope, some things are just common sense. Some of the things that we put, all the jury instructions are always going to have an element that says you can use your common sense, jury. And so some of what was in our checklist, for example, like treat people with respect, or, treat people with dignity when they go to the bathroom, right? And so those were common sense items that were on the checklist that I was really ready to have that argument. Because think about it, defense counsel looks foolish if they want to get up and say, she needs to remove this, that people have to be treated with dignity
and respect. Yeah. Yeah. That's not in the law. We don't have that. Yeah.
Yeah. Right, that's right. But I get it. AI tends to be a people pleaser. I'm a cynic. I guess I've been doing this a long time. So sometimes I have fights with chat, like, come on, how about give me a no every now and again? I need some help here. I don't need you to give me a yes man.
Yeah.
But it was not a one and done. That's what I want to say, is that I don't think people will outwork me. And so that takes a lot of time. What I'm saying is it wasn't one sit down with AI and say, let's come up with this. It was, leading up to trial, probably multiple days and hours. I found myself sitting here for like 2 hours one time, just nonstop having a conversation with AI about how to try this case. Even during trial, how pieces of evidence were coming in my hotel room between day 1 and 2. I was, making sure that I had met my burden of proof, like with using AI to make sure what I knew came in, because we had the exhibits obviously marked and could say, this is what came in, what do I need to have? And was there anything I needed for closing? And we can talk about that, because in closing, we did not have.
Let's not give away everything here in our first jump here. And now don't forget, we are going to separate this into 2 episodes. So before we get into what happened in the courtroom and you using AI during, and then also juror reactions, let's take a pause here and end this episode. And then don't forget, y'all, stick around, come back to that next episode that we're going to have to talk about how it worked out in the courtroom. Our next episode, Michelle's going to tackle how did she use AI during the trial, and also how did it work in the courtroom, like jury visuals, how did you know it was working, and then, of course, talk about the verdict.
Thank you so much. Appreciate it.
Okay, until next time, keep on prepping to win. And that's it for part 1 of my conversation with Michelle Gessner. We've covered how she used AI to build objection-proof court visuals, organized her trial prep with focus groups, and got ready to try a case in a courtroom with literally one outlet. But here's what you don't know yet, so tune in. How did she actually use AI during the trial itself? What did the jury think of her visuals? And more importantly, what was the outcome? What was the verdict? Don't miss part 2. That's episode 171, where Michelle walks us through exactly what happened in the courtroom. And if you want more trial prep strategies just like this, but in more depth, delivered straight to your inbox, grab my email newsletter I send out each month. You will get a trial prep newsletter, which will have episodes and also deep dives, and my second email, which is a focus group trends, where you learn what is happening in jury research right now. The link to that newsletter will be in the show notes. Until next time, keep on prepping to win.